Okay, that's the recording started. So good evening, everyone, and welcome to our session tonight on the skilled worker visa. We are joined here today with Carter Thomas Solicitors. I hope you can all hear me. Can I get a thumbs up to know that you can hear me? Yeah, all okay? Okay, so if you're unable to hear me, maybe you've muted your laptop, so just maybe refresh that. So we are here for the next up to 2 hours to give a briefing by our partners here, and then we are having time for question and answers. But without further ado, I'll pass you over to our colleagues at Carter Thomas.
Thank you very much, Fiona. So my name is Nick. I'm joined here by my colleague Irfan, and we're partners here at Carter Thomas Solicitors. We're a specialist immigration law firm providing assistance in a range of immigration matters, including personal and business funds. And today we're going to talk about the skilled worker global talent route in a lot of detail. I understand the purpose of this session is to talk about some of the main immigration routes available for yourselves once you come to graduation. And the skilled worker and global talent routes are often the main options. There is also, of course, the graduate route, and I understand you have a lot of internal resources available in relation to that route. So we're going to suggest that that's the best place to go rather than listen to us talk about things you already know. So in this session, Irfan's going to provide an overview of the skilled worker route and also provide some key points on the skilled worker route and also give a few examples and case studies of situations and what to do. I'm going to provide an overview of the global talent route, including the various endorsing bodies, and then talk about the routes to settlement, which I appreciate for many people is an aim of their immigration purposes in the UK. Then we're going to have a Q&A. If you do want to put your questions into the chat throughout, that would be great, and then we can address them when it comes to the Q&A at the end. And at the end, we'll also provide our email addresses. So if you do want to get in contact with us, we're very, very happy for you to do so. So without further ado, I'll pass over to Irfan and we'll take it away from there.
Thank you, Nick. Hi, everyone. Just a quick introduction. So my name is Irfan Ali, and I'm a solicitor and partner here at Carter Thomas Solicitors. So I predominantly deal with a lot of business immigration, so from skilled workers to different type of work route, but mainly predominantly skilled worker. So I'm going to just run through the first part of the session, which is just doing an overview of the skilled worker route and having a look at some of the key points in terms of this with this particular route. So I'm just going to have so just going on to the looking at this next section here then. So the skilled worker route went live on 1st December 2020, and this replaced the Tier 2 general route that was in place before then. So what happens is there's a lot of with the sponsored route, there is. I'm just wondering if you can still see my slides. If I'm having issues on that front, just think.
We can see overview of the skilled worker route continued and your panel down the side of your other slides.
Okay, let's see if I can perhaps make that some reason it's gone. All right, let me see if I can share. All right, just 1 second. Let's just see if I can perhaps retry. Sorry about this. Seem to okay. Is that any better?
Yeah, that's the whole
perfect.
slide I have. Yeah.
Right, excellent. Right, excellent. Right. So let's so start again then. So skilled worker route. So yeah, so this went live on the 1st December 2020, replacing the Tier 2 general route. So with this, now basically all the new workers now is referred to as the skilled worker. So when the Home Office look at these applications, they basically treat it seamlessly as a skilled worker route. Settled workers and non-settled workers who already have permission to work do not require sponsorship. And when we refer to settled workers, this includes those individuals who have indefinite leave to remain and or enter in the UK. It also includes other individuals as well, and the Home Office guidance does make reference to this. With regards to non-settled workers, this relates to those who have permission to work in the UK, for example, where they have permission as a partner or the spouse route or student visa in subject to certain restrictions. EU, EEA, and Swiss nationals do not need who do not qualify under the EU settlement scheme have been able to make an application under the skilled worker route from 1st of January 2021. And those who have permission under the EU settlement scheme, they don't need to apply under the skilled worker route. And we've set a link out here just in relation to the relevant immigration rules for these individuals that need to make an application. With regards to any employers who want to sponsor a worker under the skilled worker route, they must first have a sponsor license. Now, when we refer to employers, this can include all sorts of organizations, including businesses, charities, schools, and not-for-profit organizations. But the first step is for them to have a license in place. Now, this is quite important consideration, especially when when people are studying and they're coming to the end of their studies and they're looking to find a job. And we do get a lot of scenarios where students have found an employer, but they don't have a license in place. So that does have an impact in terms of timing. So if the organization doesn't have a license, they will need to then make an application for a sponsor license. This usually involves having to complete a form, providing some documents to the Home Office. And generally, with these applications, it can take about 8 to 10 weeks for the Home Office to process the application, although it is possible to opt for the priority service, in which case there's a decision can be made within 10 working days, although the service is quite limited. And with the sponsor license, it does come with a whole set of sponsor duties that the sponsor must comply with, and these predominantly are set out in 4 sets of guidances. Part 1 of 3 of this general sponsor guidance, and then there's also a route specific guidance as well, and that can be found on the link on the slide there. So with the skilled worker route, this is predominantly a points-based category, although a lot of the decisions don't really make reference to the actual specific points as such, but it is still a points-based category. And a total of 70 points are required. 50 points are non-mandatory. So 50 points are non-tradable, but these are mandatory. So this relates to having a cause, which is having a job offer from a approved sponsor, job being at the appropriate skill level, and then 10 points is for meeting the English language requirements. The other 20 points, which we will come on to shortly, relates to the salary requirement. When it comes to the application itself for the skilled worker, there's a number of things that the individual will need to have, and we will have a look at some of these in a little bit more detail, but I've just summarized here the main things that the individual need. First of all, they need to have the certificate of sponsorship from an organization that has a sponsor license. They need to have a job offer at the appropriate skill level, speak English at the required skill level, have the proposed salary that is at least the minimum salary threshold or the going rate, so whichever is higher. And also as well, depending on where the application is being made from, there are also other requirements as well, such as TB test or criminal record certificates that will also need to be provided with the application. So the skilled worker route is generally the preferred option for both organizations and individuals because it does come with a lot of benefits and is quite flexible compared to the routes that were available previously. And this is designed primarily for employees, but it can also be used for non-employees in certain scenarios, for instance, self-employed. So, for example, we have a number of cases where we've helped with dentists who are normally self-employed, and they tend to use this this route as an option. And the job itself can be full-time or part-time, and providing, of course, that the minimum salary requirement and other requirements are met. And the sponsorship itself can be for a short stint of work or for longer periods. So sometimes what we find is with this route that sometimes overseas staff may want to come on this route where because of the nature of the job or the task that they need to do doesn't fall within the permitted activities of the visitor route, so they can then use this route as a way to come into the UK to do work. And sometimes it can just be for 6 months, and you can sponsor, workers can be sponsored for as little as 6 months if they want to, with this route. And Nick will discuss a little bit more in detail as to the routes to that settlement, but the skilled worker route is a route that does lead to settlement once they've completed 5 years under this route. So it is an attractive route for a lot of individuals for that reason. And basically, once you're on the route, it just starts to clock in terms of when they can apply for settlement. And again, with this route, it's also possible to for dependents to join to join the main applicant with the application. In terms of looking at the application itself, this can be made from within the UK, providing the individual has leave. Generally, this can be in any immigration category, apart from holding leave as a visitor, short-term student, parent of a child student, seasonal worker, domestic worker, or if they have leave outside the immigration rules. Normally, we tend to find one of the main obstacles with these kind of situations is where the individual has leave as a visitor. So if they don't meet the requirements, they will then need to leave the UK and apply for entry clearance, and the application must be made from the country of residence or nationality. So if someone is a French national, the application would be made from France, or if they were residing in the country where they hold permission to stay, they can apply from that country. So you can't make an application from another country if you're just visiting there. With the applications for in country, the Home Office did make some changes when it comes to students. Because students can still make an application in country to switch from the student route into the skill route, but providing they meet certain requirements. So if the student has completed the course of study, they can basically make an application on that basis. Or if they are studying on a course at degree level or above, and they can apply before completing the course to switch into the sponsored route, as long as the employment start date is not before the course completion date. And usually a lot of students tend to fall within this bracket. So this is something that would need to be taken into consideration in terms of working out the actual start date, and also taken into account when the individual's visa expires. The other route is also as well, if those studying on a PhD, they'll be able to switch into this route after 24 months of study. Looking at the certificate of sponsorship itself, so a sponsor must firstly assign a cause to an individual that they want to sponsor. Now, a cause itself is not a paper document as such. It's a database record which confirms details of the intended sponsor worker and the job that they will be doing. This is provided directly to the Home Office, and this is done via the SMS, which is the sponsor management system, which is the online portal used by sponsors. And this usually includes information related to the individual, role, salary, etc. With the cause itself, this is something that's not transferable. So if an individual is moving from one sponsor to another, this requires a new application and therefore a new cause. And we do find instances where people have been able to secure a cause, and they then got the permission under the skilled worker route, but then they want to change jobs and they found a sponsor, a new employer, sorry. So it just means that you won't be able to port across straight away allow that. You will need to still be issued a new certificate of sponsorship and then apply for a new application as well. Now, the two types of causes. So we've got the undefined cause. Now this is for individuals applying within the UK. And something to bear in mind here is that if the organization has a license, they'll check whether or not they have any causes on account. If they don't, they'll need to apply one. Generally speaking, this can take up to 18 weeks for the Home Office to process a cause request, but it is possible to opt for the priority service, and a decision can be made within 5 working days. But the priority service is extremely busy, and it can take several weeks to try and secure the priority service. The other one is defined certificate of sponsorship, and this is usually applicable to individuals applying from overseas. And the way this system works, it's a specific request that's made as and when needed. And generally, the Home Office tend to process these within 1 to 2 working days, although we have been recently seeing that it can take up to about a week or 2 for the Home Office to process requests. This is obviously assuming that the Home Office don't request any further information documents, in which case it can take considerably longer for the request to be processed. So once the cause is on account, it can then be assigned to the individual who will then need the reference number in the skilled worker application. So when it comes to doing the application and the certificate of sponsorship, there's various fees that need to be paid, which are predominantly the immigration skills charge and the certificate of sponsorship assigning fees. There are certain categories that do reduce the fees or exclude them entirely, as well, depending on the role and the category that's going to be made. But one thing to bear in mind is that when the guidance makes it clear that the immigration skills charge must not be passed on to the worker. So this has to be paid by the employer. And we have seen instances where the employer wants the individual to pay all of the fees, because they're offering them sponsorship, but the guidance does make that clear that only the immigration skills charge can't be passed on to the worker. And then with the cause itself, once it's been assigned, this must be used with the skilled worker application within 3 months. Otherwise, it will expire. So now moving on to the skills level and the role. So the job that a sponsored worker will be employed to do must be at a minimum skill level. And the minimum skill level for a sponsored role is RQF level 3. And this is broadly equivalent to A levels. And when we refer to the skill level, this relates to the level of job itself and not the level of qualification required by the applicant. So the job itself has to be an eligible occupation code, and the sponsor must choose an appropriate occupation code. An application can be refused if a less appropriate occupation code has been selected. And this can be, for instance, where the appropriate occupation code for the job is not eligible for the skilled worker route. The appropriate occupation code for the job has a higher going rate than the salary that the sponsor intends to pay the worker, or basically where the Home Office are looking at it and they're not satisfied that it falls into one of the appropriate codes. Now, generally, this is particularly important when relying on new entrant rates, because a lot of people tend to rely on this in terms of being able to get the reduction. So I think when we look at occupation codes, there is the tool that's available online, which is the Cascot Occupation Coding tool. This provides further information about the specific the occupation code, and it gives example tasks that should be performed. So it is important that when these assessments are being made in terms of the role and the occupation code, that the most appropriate code has been selected, and this must and the job itself has to reflect the roles that the individual will be doing, because it can be something that can be picked up by the Home Office that have the concerns as to the role and the occupation code that's been selected. All of the occupation codes are listed in the immigration rules under appendix skilled occupations in table 1 to 3. And with each occupation code, it also lists example jobs which fall within the code, as well as the going rate. And what you'll also find in appendix skill occupations is table 6. Now, this sets out all the roles which are not eligible for sponsorship. So sometimes it's always quite good just to have a look at this, table just to have a quick look through to see whether or not the role that you've identified is actually going to be eligible for sponsorship, because if it falls into one of those roles, it's not going to work, and likelihood is that the employer is not going to be wanting to sponsor the individual. So looking at the salary requirement, so there were significant changes to the skilled worker route that came into effect early this year, and this particularly related to the salary requirement. Now, and we will have a look at some of this in a little bit more detail in terms of the salary, but each role must meet the salary the salary threshold or the going rate, whichever is higher. Now, the general threshold is the minimum salary which applies regardless of the applicant's occupation code. And the threshold is the same. And again, this is regardless of how many hours a week the applicant will be sponsored to work. So it can't be prorated for part-time work. With the occupation code, each one has a specific going rate, and again, this is the minimum salary which applies to a particular occupation code. Now, there are a number of discounts that can apply depending on the specific circumstances of the applicant, and these are set out in the immigration rules. There are now 11 options to choose from. Option A to K. Before there were only 6, but since the changes being brought in, they've now introduced 11. So it's important when you're looking at these tables to navigate through carefully to ensure that the applicant meets the relevant requirements based on the specific circumstances. And when we look at salary, the Home Office only take into consideration the guaranteed basic pay. So this is before income tax and employee pensions and national insurance contributions that can be relied on to meet the salary requirements. So the salary doesn't include other pay and benefits such as bonuses, in-kind benefits such as health insurance, or where they've made payment as part of the immigration health surcharge, for instance. The going rate for the occupation codes listed in appendix skill occupations are based on a 37.5 hour week, which is prorated. So it is possible to have lower or higher hours, but this will impact the salary that the individual will need to be paid. So this will be something that need to be calculated depending on the circumstances to ensure that the requirement is going to be met. As I mentioned earlier, sponsors, having a sponsor license it's something that's quite costly for organizations, and it does come with a lot of responsibilities. Essentially, the Home Office are, basically placing trust on the sponsors and outsourcing some of the responsibilities that the Home Office would do. So with that comes with having to comply with a number of rules, and these are set out in the sponsor guidance. They have to comply with the general UK legislation, and this includes not just for immigration but also employment law legislation that also falls into that. They have to make reports to the Home Office on a general basis, and also retaining any relevant documentation as well. So there's a number of things that the Home Office would need to comply with. So what's the sponsors that would have to comply with. So moving on to the next section, we're just going to have a look here now at some of the key points that I've just touched on a bit. And one thing that I mentioned earlier was the increases to the salary threshold. Now, the government made some big changes, and this came into effect from the 4th of April. So the changes apply to any new applicants with a cause that was issued after 4th of April 2024. Now, essentially, the general salary threshold was raised from 26,200 to 38,700, which, as you can see, is quite a big steep in a hike in terms of the minimum salary threshold. And obviously, this has impacted a number of organizations reconsidering the whether or not they want to sponsor individuals, or being a bit reserved with if they want to go ahead with this in terms of any new sponsorship. The general threshold for national pay scales is now 23,200. This also increased slightly as well from 4th of April. Now, the increase in the minimum salary threshold will not apply to those who are already on a skilled worker route. So those who were under skilled worker route before the 4th of April, these changes won't apply to them, although there will be some increases that will need to be taken into account, because the previous annual going rates were set at the 25 percentile of the annual survey hours and earnings, just based on the 2021 data. And the going rates for new applicants has increased from 25 percentile to the 50th percentile for each occupation code using updated data. So the Home Office have basically done a revamp of everything, and they're basically using updated data now when they calculate salary. As I mentioned before, those who hold permission under the skilled worker route or have a course that was assigned before 4th of April 2024, they won't be impacted immediately. But when they be making an application for an extension or for the settlement, there will be salary increases because of the data changes. So this is where they've got slight increases in the actual salary. So it's important to have a look. So the Home Office does set out this within the guidance, and it can be quite confusing because it makes reference to the current rules, but there is also some reference made to the previous rules as well. So it's important to have a look at which bracket the individual falls into, and then apply the relevant rules that they fall into. So just put this into context then. So we've got, for example, a software engineer, the going grade was increased to 36,300. Previously, this was 34,000. Now, after 4th of April, if a software engineer is looking to, if an employer is looking to sponsor a software engineer, the going rate is 49,400. So quite a big steep in terms of the actual going rate that needs to be met. So the median percentile does not apply to non-national pay scale and the health and care worker jobs. These remain at the 25 percentile, and jobs on national pay scales remain at the same level as the national pay scales. So for those who were on, for those where the salary requirements of base national pay scale, the general threshold is the 23,200. Having a look at the immigration salary list. Now, this has been replaced. So previously this was referred to as the shortage occupation list, and this was now replaced by the immigration salary list. And the other big change that the government also brought in, that they ended the 20% going rate discount. So this again has, because a lot of sponsors rely on the jobs which fall into the immigration salary list, and obviously no longer having a discount does make an impact in terms of being able to, whether or not they're able to sponsor certain individuals in certain roles. The immigration salary list is something that the government basically considers it to be, whether they want to offer a discounted salary rather than being a list of all occupations experiencing labor shortages. And now the list is at about 23. Previously, there was about 80 or so occupations that was on the list, but that was massively reduced. And I think this probably something that will be under constant review from the Home Office, and this will probably get updated fairly frequently on that. And where sponsor is looking to rely on the immigration salary list, the salary will have to equal or exceed 30,960 and the going rate of the occupation code. The other option that people tend to have a look at to see if they can reduce the salary that needs to be met is looking at the PhD. So when applicant has a PhD in a subject that is relevant to the job that they're being sponsored for, this can mean that the lower salary threshold can be applied. Now, to rely on this, applicants must be sponsored under the specific occupation codes, but not all occupation codes are eligible for tradable points for relevant PhD. And we've just set out here, so the occupation codes have a yes listed in column eligible for PhDs as shown on the slide. So again, this is available on the immigration rules. So it's a good reference point just to have a look at just before before people make want to apply for jobs, whether or not actually it is going to be something that they can look at in terms of lowering the salary. So with a PhD provision, so there's different requirements that can be met. So with a PhD, the salary must equal or exceed 34,830 per year and 90% of the going rate for the occupation code. If the PhD is in a STEM subject, so qualification in science, technology, engineering, or mathematics, the salary can be reduced. The minimum salary will need to equal exceed 30,960 per year and 80% of the going rate for the occupation code. So the salary has to exceed or be equivalent to the discounted salary rates for both the general salary and the going rate of the occupation code that's going to be relied on. When relying on PhDs, the applicant will have to provide evidence of their qualification. And where this option is being relied upon, and the individual would need to provide their PhD certificate and verification from ECDIS, formerly UK NARIC, if the qualification was obtained overseas, stating that the qualification is genuine and equivalent to a UK PhD. And the sponsor will also need to provide a credible explanation of how the qualification is relevant to the job. And the evidence of the relevant PhD along with the supporting documents will need to be uploaded to the portal when the application is being made. And where the PhD qualification relied on is a STEM subject, the same requirements will apply, and the sponsor must provide a credible explanation as to why the qualification is in a STEM subject. Now, generally, the Home Office take a fairly pragmatic approach. So if the company is clearly a bio or chemical tech company, for instance, and the role is a scientific researcher, the explanation can be fairly straightforward. If, however, if the individual is trying to rely on this option to a case that's not immediately obvious, a more detailed explanation will need to be provided. Moving on to the next section with new entrants. Now, this option lowers the salary thresholds even further and applies where the individual being sponsored is considered to be a new entrant to the labour market. Now, when we say new entrant here, we mean a new entrant to the labour market, i.e. someone who is near the start of the career and who meets certain criteria. It does not mean an applicant who is making their first skilled worker application or entering the UK for the first time. So we tend to find that this has now become a very attractive option for a lot of sponsors, especially with those who fulfill this criteria, because it does reduce salary quite a bit. And in terms of salary, the salary has to equal exceed 30,960 and 70% of the going rate. So, for example, for a software engineer, the standard going rate is 49,400. As a new entrant, this can be reduced to 34,580 pounds. It's quite a big reduction in terms of the salary that needs to be met. So the Home Office guidance does set out what they define as a new entrant. And this is someone who is switching from the student graduate route to the skilled worker route, someone who is aged 26 years of age or at the age of application is under the age of 26, or someone who is working towards a recognized professional qualifications or moving directly into postdoctoral positions in specific occupation codes. And the Home Office guidance does set out further details as to what that actually entails. Now, something to bear in mind with when relying on new entry, because a lot of people do get caught out by this, is that it's only possible to rely on a new entrant for a maximum of 4 years. And this includes time spent on the skilled worker route or the graduate route. So essentially what happens is that any time spent on that route, it's max 4 years, and then if the sponsor wants to sponsor the individual any longer than that, They would either need to sponsor them for the full 5 years, but then not rely on a new entrant, or sponsor them for 4 years, and then they will need to then make another application at a later date, but that will be at the higher rate because they won't able to qualify for the new entrant. So we're just going to now look on, have a look at some of the a few case studies. So here we've got a role that's advertised for a management consultant with a salary of £31,000. So there's a few things that need to be considered here. So first of all, you need to ask whether or not the organisation has a sponsor license, or do they need to get one? Just something will need to be looked at fairly early, especially if the organisation needs to apply for a license, because that can impact in terms of the timings with an application. The other thing that we need to have a look at is whether or not the salary and skill requirements would be met. So in this instance, so a possible occupation code could be 2431, management consultants and business analyst. So the going rate for new entrants under this code is 33,600. Although it's just above the general threshold of 30,960, this may be something that you may need to have a look at with the employer as to whether or not they would consider raising salary, or have another look at the occupation code to see whether or not this is the most appropriate occupation code for this for that particular role. In this scenario, we've got a role that's been advertised for a travel agent, and this is for a salary of £40,000. Again, there's a few things that we need to consider in terms of whether the organisation has a license and whether skill and salary requirements would be met. Now, generally, only travel agent managers would meet the skill requirement. Now, when you look at table 6, this, as I mentioned earlier, this sets out all the occupations code which are not eligible for sponsorship, and this does include travel agents. So with these type of roles, it's very important to be clear as to what exactly the role entails, because this is something that the Home Office would look at very closely, especially if they suspect if the role is fairly similar to something that's not eligible for sponsorship. The Home Office will probably want to know exactly what the role will entail, what the individual will be doing, etc., and making sure that the sponsor has selected the most appropriate occupation code. Otherwise, the Home Office could refuse the application. So although in this case the salary requirement would be met, the skill level may not be met. So it's worth having that conversation with the employer at the early stages, just to make sure that there's no any misunderstandings in terms of the actual role itself. And then for our final case study, here we've got a role that's advertised for a care worker with a salary of £39,000, and the organisation has a sponsor license and wants you to pay all costs associated with the sponsorship. So there's a few things to consider in terms of the skill and salary requirements, and here the role and salary may be met, but as I mentioned previously, there's only, although some fees can be recouped by the sponsor, the immigration skills charge can't be passed on to the worker. So this is something that you do need to be mindful of in terms of when you look at these, and when the sponsor asks for making payment in terms of the fees. And along with the change that was brought in earlier this year, care workers generally now can't have skilled worker dependents, so this will only be applicable to the main applicant when making these applications. So I'm now going to hand over to Nick, who will take you through the next section of the session.
Thank you very much, Irfan, and that was a great overview and a great set of case studies as well. If anyone does have any questions, please do pop them in the chat. We can answer them at the end as well. In this section, I'm going to cover the Global Talent route. I am a partner here at Carter Thomas, and I lead on some of our personal work, including Global Talent as well. So again, our emails are at the end of the slides. If you do have any questions that you don't want in the chat and you want to reach out to us individually. So the Global Talent route is a category designed to enable those who are endorsed as recognised or emerging leaders in their field to come or remain to work in the UK. It's for leaders and emerging leaders in some specified fields, including arts and culture, digital tech, academia, or research. It's an incredibly flexible immigration route. It allows an applicant to work for any organisation and in any role. For future settlement applications, you have to demonstrate you've earned money in your field since you were endorsed, but there's no specific time limit to have worked, and I've relied on as little as 1 month's income previously. So this flexibility, the fact that you're not tied to any specific organisation as you are under the skilled worker route, or indeed any specific role as under the skilled worker route, plus the prestige of this route, you know, it's quite nice to be known as a global talent or indeed as an emerging leader in your field, does make this quite an attractive option. And I understand this is a realistic option for some of you, which is great. We will talk about some of the options, especially for those just coming out of university. So individuals would generally be assessed against the following. So exceptional talent criteria. This assesses individuals who can show that they have already made a significant contribution as a leader within their field, or exceptional promise criteria. This assesses individuals who are at the start of their careers, show promise in making contributions to the sector. So don't let this sort of fuzzy language fool you. This is a high standard. Exceptional talent applicants are often world leading. Exceptional promise applicants have to show that they have the potential to be world leading. So incredibly high standard. Individuals will generally need to be endorsed by an approved endorsing body, and they themselves have a number of specific requirements which we will go through. Generally, it is beneficial that a panel of experts, which is how the endorsing body works, reviews your work and your plans for the future, rather than a Home Office official who is not an expert. This route is designed so that experts are making decisions for those who will be contributing to the field or are world leaders in their field. So because of that, you can obviously have promise in very niche areas, or indeed talent in very niche areas. In general, we do see endorsing bodies as quite open and fair, apart from perhaps TechNation. As I say, often a high bar to meet the requirements, and the endorsing bodies are often not afraid to say that an applicant is a bit too early in their career to be considered, for instance. So in terms of the endorsing bodies, they are Arts Council England for arts, culture, architecture, fashion, film and television, British Academy for Humanities and Social Sciences, Royal Academy of Engineering, surprise, Royal Society for Natural Sciences and Medical Science Research, TechNation for Digital Technology, and the UK Research and Innovation Centre, so UKRI, Science and Research. And we'll come on to the distinction between UKRI and the British Academy and Royal Society. Some disciplines between the British Academy and Royal Society in particular can bleed into each other, and there is a helpful list of eligible disciplines and which body to apply under. And it's also worth noting at this point that some fields are not eligible under these routes at all. For instance, journalism, and that's often a shame, because some journalists do obviously contribute to the arts and culture scene as well. So individuals who wish to apply under this route must make an endorsement application and a short visa application. The endorsement application can vary in length and intensity, but generally there is a 10-document limit and an opportunity to provide a personal statement explaining your plans for the future and the ability to provide your CV. If the endorsement is approved, Global Talent visa applicants must make their application within 3 months of the date that their endorsement was received. So it's a two-stage process. First stage is you get an endorsement from the endorsing body. That's the high bar. That's where you have to demonstrate you're a leading, potentially leading expert in your field. Once you've got that, you then need to make the immigration application within 3 months, and that's a relatively straightforward application. If an applicant is endorsed as exceptionally talented in any route or exceptionally promising under the academic and research routes, they can apply for ILR or settlement after 3 years residence in the UK. Again, it's another reason why the route is so beneficial, because it does lead to accelerated settlement. Dependents are permitted under this immigration category, however, they're not eligible for the accelerated route to settlement, so they'll have to complete a full 5-year period of residence in order to qualify for ILR or settlement, which is a frustrating aspect of this route and something we hope will change in the future, but hasn't as yet. So we're going to go through each sort of section in some more detail now. So for arts and culture, the endorsing body is generally Arts Council England. They undertake reviews on behalf of some other organisations, including the British Fashion Council and the Producers Alliance for Television and Cinema. Disciplines include dance, literature, music, visual arts, and those who work in film and fashion designers. Some disciplines are not eligible, as we discussed, although there is an appreciation that there are some mixed disciplines, which allows a bit more scope there. The specific endorsement requirements can vary depending on the discipline, but generally applicants need to meet 2 out of the 3 requirements, and we'll go through these in a bit of detail. So the first is provide evidence of media recognition. This is normally national or international media recognition for the quality of your work in the form of detailed independent reviews, critiques, or critical evaluations of your work from credible critics in established media outlets. There is scope if applying as part of a group, but further evidence needs to be provided. They're fairly strict on the fact that it has to be a critique. Often a sort of profile is not by itself enough. The second is providing evidence of international awards. This needs to be within the last 5 years, and the award has to be relatively significant. This is often a hard one to rely on, and degrees, masters and PhDs, as well as student or academic awards, grants and bursaries are not applicable for exceptional promise, but full scholarships or fellowships can sometimes be acceptable, such as a full scholarship to attend an artistic undergraduate or postgraduate course at a recognised university or art school. So there is, again, a bit of scope there for potentially applicants such as yourselves. And the third point is provide evidence of appearances, publications, exhibitions or distributions. Again, you can see the breadth of this. You know, if you're a writer, for instance, you're focusing on distribution. If you're an artist, you're looking at exhibitions. So it's covering a whole range of disciplines. This needs to be in 1 or more countries, and evidence can include things like adverts, posters, letters of support for things like performances, exhibitions, or indeed distribution data, such as where the work has been sold for other areas as well. So it's often difficult, but not impossible, to meet the requirements immediately after graduation. The scope of requirements such as distribution is relatively wide. For instance, I had an author who sold a few hundred books and had a couple of local media recognitions articles where they did critique his work, and this was approved. That was enough. So it's a relatively wide scope, so it may be worth considering if you do operate in that area. There is no exceptional promise option for those who work in film and TV, unfortunately. It's exceptional talent only. Again, the standard is quite high. Fashion designers can rely on specific provisions for exceptional promise applicants, including having produced an exceptional graduation collection. And all applicants need to include specified referee letters that have to meet specific requirements and come from eminent individuals, cultural organisations. And it's important that these sort of reflect the wider body work and argument that you're making about how you are exceptional, i.e. they need to make reference to some of your key skills and not be entirely separate from the evidence you are providing. So for tech applicants, this is unfortunately one of the more difficult endorsing bodies. There's a 50% refusal rate. The requirements have become increasingly pedantic. I've written quite a few articles about this and become quite frustrated with TechNation over the years. So applicants will need to demonstrate 2 out of the 4 requirements. The first is a track record of innovation in the digital tech sector. So that's quite a high level. So it includes things like patents and evidence of producing a new product. So quite a high expectation of what innovation is. The second is recognition for work beyond your occupation that contributes to the advancement of the field. So that includes some specified voluntary and mentoring work. Again, this is where the pedantic nature of TechNation comes in. It's increasingly difficult to meet this requirement now, which is reducing the approval rate further. The third is significant technical, commercial, or entrepreneurial contributions to the field. That's quite similar to innovation, but what they're looking for is outcomes. So outcomes of your work, such as an increase in profits of the company, an increase in safety standards, for instance, and there needs to be evidence of that. And the final one is academic contributions through research, which is endorsed by an expert. Applicants also need to demonstrate that they have been recognised as, or having the potential to be, a leading talent in the digital tech sector in the last 5 years, and evidence can include earning a high salary. Again, referee letters need to be provided, but this is, as I say, a particularly discretionary route, and the endorsing body is due to change by the end of the year, which is really good. We don't have any details yet as to what will be replacing it, or indeed what the requirements will be. So hopefully they may be a bit easier to meet. So watch this space. We will be updating our website as we go forward. So under academia or research, there are a number of ways to receive an endorsement under this option. This is probably the area most of you are interested in, which is great. And we'll go through this in a bit of detail. So the first is appointments. This is applicable for those who have accepted a position at a UK higher education institution, so university, or indeed a research institute. And they have to have responsibility for academic research or innovation leadership and development. So this is for individuals in senior leadership roles at departmental, faculty or institutional level. So that's quite a high level. Again, depending on what you have been offered, if this does apply, it does depend on that seniority there as well. But the alternative is you direct or lead an individual or team in research project or research program of work, or an innovation project or innovative program of work. So in general, this requires you to act independently in initiating, planning and managing a research or innovation project or research or innovation program of work without supervision. And the guidance does quote that this is likely to make you ineligible if your role is in an entry-level postdoctoral research position. So again, something to focus on. If your role involves teaching and curriculum development, your endorsement application must confirm that directing or leading a research or innovation project program is a significant function of the role alongside your teaching and learning responsibilities. If this is the case, so if you do meet that appointments criteria, you can provide a job description setting out the duties and responsibilities of the position, and you also need to provide a statement of guarantee to the Director of HR or equivalent that must meet specific requirements. And there is a specified list of research institutes, you'll be happy to know, that meet the requirements here, but of course all universities meet the requirements also. So the second way to meet the endorsement criteria under the academia research route is individual fellowships. This is pretty straightforward. It's applicable to those granted a specific fellowship or who have held it 5 years directly prior to the date of application. There's a list of applicable fellowships, and this allows a fast-track process, so indeed as the last one. The list of fellowships is updated relatively frequently and includes specifically postgraduate fellowships, including the British Academy Postdoctoral Fellowship, for instance. And then the peer review. This is not fast-track, so it's a bit of a slower way, and it's often difficult for recent students to meet these requirements. Applicants need to provide a letter of support from an eminent person, provide details of their publications and awards. The endorsing body are considering your originality, creativity, independence, and intellectual leadership. You have to be an active researcher, for instance, in a university, a research institute, or an industry. You don't necessarily need to be employed. So I've been successful with a visiting fellow, for instance, so it's something to consider. You do need to have a PhD or equivalent research experience, and the endorsers review your track record, career history, contributions to the field to date, including your international standing, significance of your publications, your prizes and research, and funding awarded, patents, licenses, and spin-outs. So there's quite a few aspects they do consider there. Letters of support are really crucial here. They really make the difference in creating a narrative about how you meet the various requirements. Then finally, UKRI. So this is one of the most common ways to meet the requirements. It's applicable to those who have their name specified or their job title specified in a successful grant application. That distinction is important. It does appreciate that if your name is specified, it's probably a leading aspect of that grant. If your job title is specified, then you are contributing to it, which is helpful. You'll be hosted or employed in a UK research organisation named on a specific list. You're essential to the execution of the grant or award. Again, if your job title is there, that can help. The funding is approved by UKRI. The grant or award is worth a minimum of 30,000, and it covers a period of 2 years. There is a specified list of endorsed funders and of host organisations, and the research organisation itself should be able to provide some supporting documents that meet the requirements. This is generally a letter from the Director of HR again, and the organisation where you're working needs to set out the name of the position, the department where you'll work, that you've accepted the job offer or hosting agreement, that you are essential to the grant, or indeed your job is, that you'll be spending at least half of your agreed working time on the grant, that the details of the fair recruitment process, if you're not specifically named at the grant application, so that may require a little bit of work depending on what went on there. And in general, you need to have an employment contract or hosting agreement lasting at least 1 year, and the intention to spend at least half of your time working on the grant as well. So there's quite a few different aspects to meet there, but generally UKRI organisations are quite experienced at providing these documents and getting applicants onto this route. It is beneficial for them and for you because it allows you to work for them, and it means that they don't have to think about any sponsor duties as if I was talking under the skilled worker route. So it is worth considering if this does apply to you as well. So now we're going to talk about routes to settlement. So this is looking forward to consider the pathways to settlement and some things to think about which may impact your various choices here. So settlement is also known as indefinite leave to remain. We use them interchangeably. It allows one to be free from the immigration system. You don't have to keep making extension applications and spending all of that money. You don't have to keep monitoring your absences, which we'll talk about in a moment. You're not tied to any one employer or organisation as you are under some immigration routes. Those who hold settlement can work or study in the UK without restriction. It's possible to apply to naturalise as a British citizen after holding settlement for 1 year, or indeed apply immediately if you're married or in a civil partnership with a British citizen. That to be a British citizen doesn't give you that many advantages compared to if you have settlement, but does allow you to do things like vote and indeed apply for consular assistance if you need it. Settlement is only generally lost if you're outside of the UK for 2 continuous years. So if you come back into the UK even for 1 day within those 2 years, that can renew it effectively. So it is quite a robust type of, I'm not going to say permission, quite a robust status. And for many people, settlement is the end goal of their application process. You've obviously spent a lot of money and time on various immigration applications up to that point, and settlement means you are free of that, which is excellent. So it does have some general requirements, a specified period of residence in the UK. In general, this is 5 years. Irfan made reference to this, but we'll talk about this in a bit more detail in a moment. Obviously, we made reference to some accelerated routes as well. Absences of no more than 180 days per 12-month period throughout the period of residence. This is a rolling 12-month period, so it can be hard to calculate and means monitoring your absences is really important. Meeting an English language requirement. Again, you had to meet that as part of getting onto the skilled worker route, if that is your chosen route. And indeed, you should meet the requirements if you've been awarded a degree in the UK, which hopefully many of you will get. Meeting a life in the UK test requirement. This is a test about the history and culture of the UK and should be a relatively straightforward aspect to meet. And meeting the general good character requirements. If there has been any good character issues previously, such as deception or dishonesty in an immigration application, this is where it becomes somewhat problematic. There are specific requirements that must be met as part of the immigration routes you hold when you apply for settlement. So if you are on the skilled worker route and you're thinking about applying for ILR, then you need to meet the skilled worker ILR requirements. If you similarly are in the global talent route, thinking about the ILR, you need to meet the global talent ILR routes despite your previous immigration history. So that is important. What you currently hold in terms of your immigration status determines what requirements need to be met. So for skilled workers, it is just an overview, but you need to continue to be employed by the sponsor that last issued you a COS. So that means the organisation needs to continue to hold a sponsor license. So you are still somewhat linked to the sponsor, and the sponsor, of course, needs to maintain their license. So I appreciate that gives them a degree of control over you. He needs to meet the salary requirements, which generally requires meeting their full going rate, although some discounts do apply, and must provide a letter from the sponsor confirming that they continue to be required for their role and will receive their current salary. Again, this is an intention. So of course, intentions may change in the future because you will no longer be linked to that organisation, but that letter should be provided in good faith. And then global talent, relatively straightforward. You must have earned money in the UK in the field once you've been endorsed. So that's a relatively open interpretation. Even one payslip, one evidence of funds into the bank account could be enough. And often people do that. As I say, I have relied on as little as 1 month's worth of evidence before. And the evidence can vary indeed from that. So if you're self-employed, it can change also. So skilled workers must have resided in the UK for 5 years under the skilled worker route. Global talent applicants may be able to apply under the accelerated route of 3 years. So time spent under certain immigration categories can be combined, such as time under the skilled worker and global talent route. So if you were on the skilled worker route and switch to the global talent route, you can combine those times. So if you're on the skilled worker route for 4 years, for instance, and then switch to the global talent route, you can apply for settlement straight away, which is excellent. Time spent under certain immigration routes, however, cannot be combined, such as if you're on a spouse visa or permission as a points-based system dependent with the skilled worker route. This may restart your period of residence. Just to give you an example, if you're in the UK as a skilled worker dependent, so your partner has skilled worker status, you are their dependent, you've resided on that status for 3 years, and then you think, great, I'm going to be a skilled worker myself. Once you get that skilled worker permission, that restarts your period for residence in the UK for indefinite leave to remain. So you need to do a whole new 5 years under that route. So do be careful if you're switching immigration categories. It's always worth checking whether you can combine the time before you do so. Time under the student route or graduate route does not count towards the length of residence unless applying under the 10-year long residence route, which we'll talk about now. So it's possible to apply for settlement after holding immigration permission in the UK under a variety of different routes for 10 years in total. Time spent under the student route and the graduate route can be counted for the 10-year long residence route. The permission has to be continuous in most cases. So if you were a student and came back into the UK a year later after you finished your course under the student route, for instance, this would break the long residence requirement. You'd have to start the 10 years all over again. Applicants must have permission on their current immigration route for at least 12 months before they apply. So it doesn't apply to those who have granted permission before 11th of April. There normally have to be quite a period of extensive evidence of residence throughout the period. So you'd have to demonstrate that you were physically resident in the UK throughout the 10-year period, provide a number of documents such as bills, tenancy agreements and things addressed to you. The application has become slightly more difficult in recent times, but if you are on a variety of different immigration routes, it can be worth considering. So if you are in that situation I talked about earlier, skilled worker dependent, and then switch to the skilled worker route, you may find that it's actually quicker to think about the 10-year route rather than doing a whole new period of 5 years in itself. So it is always worth having that in your back pocket. If you do switch from the student route to the graduate route to other routes, you may find that you quickly amass 10 years and can think about this route as an alternative to some of the other immigration routes that lead to settlement that we talked about earlier. Great. So on to Q&A here. I can see we've got a few questions in our chat already, which is great. I've also got a list of questions that often crops up as well. If we start with some of the list, that'd be great, and then we can let some more questions come in, which is excellent. So Irfan, if I just ask you a question first, can I switch from the student route to the skilled worker route? What are the advantages for doing so for myself and my sponsor?
Yeah, thanks, Nick. Yeah, so it is possible to switch from the student route onto the skilled worker route. As I mentioned previously, you just need to ensure that the individual has completed the course or is near about completing the course, and allowing switching from the student route into the skilled worker route gives the employer the advantage that they don't need to pay the immigration skills charge. And this can be quite costly. This can be quite a saving for many organisations. For a small employer, that's £364 per year, or for a large employer, that's £1,000 per year of sponsorship. So that is a massive saving from the employer side. And in terms of the student, again, it just means that they can get onto the skilled worker route a lot quicker. So some people tend to go from the skilled route onto the graduate route and then onto the skilled worker route. But if you can go directly onto it, it just means that you can start to clock up your 5 years, so to speak, in terms of the skilled worker route.
Great stuff. And then there's a few questions here about global talent, which I'll just cover. So the Royal Academy of Engineering, that's largely the same process as for the academic and research route. So you've got the various options there, appointments, fellowships, peer review. So follow the same process there. The endorsing bodies list, is that exhaustive? Yes, unfortunately it is. So as I say, the Arts Council does review some other options on behalf of other bodies. So Royal British Fashion Council, for instance, but that is under the umbrella of the Arts Council. It's not, unfortunately, all disciplines that are covered under there, unfortunately. So there is a degree of restriction, which I appreciate is frustrating. Great. In terms of other questions here, so I can see a question here. Are there any other ways of obtaining ILR apart from skilled work or talent? Do you want to cover that one, Fan?
So what was that? Sorry, I can't see the question
Sorry,
there.
yeah.
So what was the question there? If you
Are
could
there
remind?
other ways for obtaining ILR apart from skilled worker global talent?
Yeah, I mean, there's depending on the circumstances, there is the partner route. So, for instance, if an individual finds a British national, they fall in love, they get married, so they can switch into the partner route, and depending on the circumstances, they can apply for settlement after 5 years. There is also an option to apply after 10 years if they, if they can't meet all of the requirements. And if the individual has a British national child, they can also make an application under that basis. And again, that is also a route that leads to settlement. There's also other routes as well. For instance, a private life route. But generally speaking, those tend to come with a much higher threshold in terms of, first of all, being able to get onto that route. But it is generally possible to apply for for them to apply for settlement. But those are generally the main routes that people tend to look at in terms of applying for settlement.
Yeah, perfect. Great. I've got a question here that says, would a postdoc position be part of the global talent route given the early career in academia? So a postdoc position could potentially be part of the global talent route. So you could use that as part of a global talent application. You would have to fit it within the categories that we talked about. So if it's an appointment, for instance, it's unlikely that you'll be able to rely on the sort of directing or leading an individual team aspect of the appointments criteria. But if you have responsibility for academic research or innovation, leadership and development, you may be able to do that, but it really does depend, and it does depend on the level of your role. If you've been awarded an individual fellowship on the specified list, you could apply on that. If you have a postdoc with a specified grant that comes under the UK RI, that could be a possibility to do that. But otherwise, you could think about the peer review. A postdoc position does mean that you're an active researcher, so meet one part of the criteria, but the real challenge would be demonstrating that you are a potential leader in your field. So it really depends on your career to date to that point, so your publication history, any achievements in your field, grants won, things like that, as well as a letter of support that you can provide. I have done some postdoc positions that have met the criteria. I've had some people, for instance, whose PhD thesis was sort of published in parts as they went along in various academic journals, and they presented at very high level institutions as well, sort of the UN and that sort of level, and they did get the global talent route there. So it is possible, but it is just a matter of thinking about which of those four options that you fall under would be best for you to apply under to try and get that global talent route. Great, so quite a few questions here, which is great. One for you, Irfan. When is the right time to apply for the skilled worker visa, assuming this is the final year before graduation?
Yeah, that's a very good question, Nick. So I think sometimes it is important to plan ahead. I think because obviously, as we discussed earlier, so there's a few things that need to be taken into consideration. First of all, finding an employer and identify whether or not they have a sponsor license. And a good way to check that is there is a publicly available register online. So it just lists all the sponsors who are just lists all the organizations that have a sponsor license. So you can easily just check that register, and if that, and it'll say whether or not that organization has a license. The other alternative, obviously, is to reach out to the employer and see whether or not they're going to be whether or not they would be willing to apply for the license. And I think, generally speaking, obviously all of this needs to be factored in, and sometimes organizations can plan ahead and make the application well in advance, because ultimately that is an asset for the business in terms of having a license. Even if the individual maybe is a year off, for instance, they can still reach out, and whether or not, obviously I appreciate that sometimes that can be quite a long wait, but just having that that license in place just make that a little bit easier. But normally when you look at the skilled worker route, generally speaking, you can't make the application more than 3 months in advance of the start date. So you have a course in place and you've got a start date there, but the application itself can't be submitted more than 3 months. That is something to bear in mind. But I think, generally speaking, there is a lot of work that may need to go into that may need to be factored in before you actually get to sponsorship. So that is something to consider.
Yeah. This question here says postdoc positions are often short, so 2 years. Can time on several postdoc positions on a skilled worker or global talent visa be added up? So you can certainly switch sponsors under the skilled worker route. So when we say continuous residence under the skilled worker route, that means continuous residence under the skilled worker immigration route. You don't necessarily need to be with the same sponsor throughout the full 5 years. So you can switch from sponsor to sponsor and stay under the skilled worker route. You would have to make a new skilled worker immigration application every time you switch sponsors, which of course could be expensive. And there may be various hurdles to jump through with the new employer there as well. But if you do that and you still get to 5 years, you can certainly apply for indefinite leave to remain at the end of that. Indeed, you can of course combine time under the skilled worker and global talent route as well. If you started on the skilled worker route and then managed to go into the global talent route, once you built up your career, for instance, you could indeed apply potentially for the accelerated route to settlement after 3 years. So if you did the skilled worker route for 3 years, switch to the global talent route, you can almost apply for settlement straight away, which is excellent. So just got quite a few questions coming through there, which is great. One question is, would the university or employer immigration service be able to assist an application in the global talent visa? I'm sure Rihanna will be able to provide some further information, but I would say that the global talent application is incredibly specialized. It does require quite a high level of evidence to demonstrate that you are essentially a leader in your field, or indeed a leader in your field. As I say, it is reviewed, the application is reviewed by a panel of experts in the field as well. So it does require a high level of knowledge in that field. So it may be worth considering your contacts to see if anyone can potentially consider whether you meet the requirements of that route. And indeed, you could approach legal advisors like ourselves who can provide a formal review as to whether you meet the requirements in our opinion. But it is, as I say, quite a high level of requirements that need to be met there. So it's worth considering who are specialists in your specific area as well. Maybe a tricky one for you here, Irfan. Can I combine 2 part-time jobs with the company salary to get to the 38,700 to get to the skilled worker visa?
Oh, that is an interesting one. Yeah, I think there's probably some technical issues, some technical things to consider there, because obviously in terms of the minimum salary requirement, there is a general salary threshold that needs to be met. So I think that would be something that wouldn't be considered in the first instance, because obviously, even with part-time work, the employer would need to be paying a minimum of the general salary. So that would depend on what role the individual will be doing. So for instance, if a new applicant is going into the skilled worker route, the current threshold will be 38,700. So that's the general minimum threshold, disregarding any discounts, anything like that. So I think that would need to be considered. And generally, with the skilled worker route, it does allow individuals to undertake supplementary employment up to 20 hours outside the normal working hours. So they could technically do that in terms of having a skilled worker visa, and then do the supplementary hours in terms of that. Where the individual is going beyond 20 hours, there is there is a route to go in for secondary employment, but that requires a second cause, and that can get tricky at times. I think largely this would probably depend on the role, whether an employer would be comfortable with that, but it can get very complicated. So I think it probably very much depend on the circumstances on that.
Yeah, and you've recently had a quite complicated application of supplementary work, haven't you? So yeah, it is, as Irfan says, it can be really complex on that basis. So if I jump, a question here is, if I jump from the student visa to graduate visa to the skilled worker visa, and that reaches 10 years, would I be eligible for long residence? So there's a second question afterwards, which I'll come to. So the answer to that is yes. If it's been continuous, if you meet the residence requirements and the absences requirements, then you can certainly combine student, graduate, and skilled worker visa to get to the 10-year mark itself. The 10-year mark for some people, so I've had applications, for instance, who went to school, so went to secondary school in the UK and then did university in the UK and then started the skilled worker route, for instance. That's quite a classic way to get to 10 years. Of course, time as child student visa, or indeed as a student visa, doesn't allow you to apply for indefinite leave to remain in itself, but that does add up to the 10-year period. Of course, if you are doing that route, you do have to make sure it's continuous residence. You've got to make sure it's one overlaps the other, for instance, or is in a required time limit from one to the other, which can be a bit complicated. And obviously, you've got to monitor your absences over that period of time. Also, very few people come to the UK thinking I'm going to apply for settlement in 10 years' time. So they may not have their absences data at the start of that period, which can be problematic. You can request your absences from the Home Office. There's something called a subject access request, which is free, and that gives you the records the Home Office have about you as far as they are, as far as they're able. They're not always complete records, it's worth saying, but that may be worth doing if you are thinking about the 10-year route, and certainly something we do on a regular basis to try and get as much data from the Home Office as we can. And then the second part of the question is, for regular residency, would the 5 years only begin after the graduate visa and on the skilled worker visa, or during the graduate visa? So unfortunately, the graduate visa does not lead to indefinite leave to remain in itself. It cannot be combined with the skilled worker visa either. So if you switch to the skilled worker route, your residence for the purposes of indefinite leave to remain after 5 years on the skilled worker route would only begin once you've been granted the skilled worker visa. As I say, you can combine the time spent under the graduate route and skilled worker route for the purposes of 10 years, but the first day for your period of 5 years would be the first day of skilled worker permission if you wanted to apply for indefinite leave to remain or settlement after 5 years on the skilled worker route. So I appreciate that is a bit harsh. They do make you wait around a lot, and it's particularly frustrating when you're switching from some routes to another, which mean that your permission is quite extended, which is frustrating. So we've got a question here, Fan, about essentially about the salary requirements. Unfortunately, it's a very understandable experience. Colleagues have graduated and not been able to receive a salary greater than 30,000 the first 2 to 3 years in the field, and they're unsure as someone with only a placement year's work experience can start a graduate job reaching the threshold expected for the visa. What are their options in this case if they're worried about the salary levels for the skilled worker route?
Yeah, unfortunately, I think it's with the change that's been brought in earlier this year, it has made it a lot harder now for people to jump onto the skilled worker route. And I think ultimately, I mean, there is a basic threshold that needs to be met unless the individual is able to look at the discounted routes, depending on the roles. So sometimes some teaching roles or some health and care roles, they attract the lower general salary thresholds, so they can explore those ones. Or like I mentioned, there is other PhD or new entrants or the immigration salary list again that does reduce the general minimum threshold. But again, that very much depends on the actual role itself. I mean, the other alternative is if people aren't, if they're not going to meet the requirements of the skilled worker route, is whether or not they explore other options in terms of looking at that. And sometimes, and we often find situations where employers would prefer to have recent graduates come in to work with them. A lot of them would probably be on a graduate visa. So where they spend that 2 years working with them, gaining the experience, getting the knowledge and know-how, etc., and then they may consider to then look at a sponsorship. And by that point in time, the likelihood is that they have amassed experience, and they would be probably at a position where the sponsor would be comfortable with giving the individuals the relevant salary that might then make them eligible to apply for the skilled worker route.
Yeah, absolutely. That's something we see quite often, isn't it? I found that sponsors come to us asking to sponsor someone who's already working for them as a graduate. Obviously, you've got great resources about how to apply under the graduate route and the various requirements of that, but it is quite a traditional route to go from the student to the graduate route, and then from the graduate route to the skilled worker route once you've found an employer. Obviously, it is just a matter of finding the right employer for yourself, someone who wants to get a sponsor license, and there is a role there eligible for sponsorship that they're willing to sponsor you under. So it's certainly worth giving that an option first and before sort of giving up all hope. And then some further questions that often come up, just looking over here. So one of them is about the global talent route. for the purposes of a settlement, can they rely on the work that they've undertaken outside of the UK? It's an interesting question. Unfortunately, the requirements are fairly clear that it needs to be work undertaken in the UK. That can get a bit hazy. So, if you're based in the UK and your research project is outside of the UK, there is a question mark there about, is that work outside or inside of the UK? Generally, I see the Home Office are fairly understanding, especially for global talent applicants. Part of that prestige seems to rub off with Home Office caseworkers, and they do generally give you the benefit of the doubt. But if you're physically based outside of the UK, the project is based outside of the UK, that probably wouldn't meet the requirements for settlement under the global talent route in itself. Another question that's coming in there, Irfan, is can I be self-employed under the skilled worker route?
Yeah, it is possible to be self-employed under the skilled worker route, and generally we find this with some professions like dentists, as I mentioned earlier, barristers also. A lot of them do tend to be self-employed. I think the main thing that needs to be taken into consideration is that although they may be self-employed, the sponsor still needs to meet their obligations in terms of keeping so a lot of times they need to be in control of in terms of what tasks the individual will be performing, in terms of monitoring the individual as well, in terms of absences, etc. So although the actual relationship may be of a self-employed relationship, but there is still that aspect of almost employee type of a relationship, because the sponsor still needs to have that overall oversight in terms of making sure that they're meeting the sponsor requirements. I think that can sometimes get a bit complicated in terms of managing that in practice, but it is something that the Home Office do tend to look at. And if they were to do a compliance visit, that's something that they probably will ask in terms of how are they meeting the obligations and the sponsor duties in terms of keeping track of the individuals. Because sometimes, where if an individual hasn't turned up to work for 10 consecutive days, that 10 consecutive days, that does need to be reported. So the Home Office would ask, how do they monitor all of that? So I think there is that relationship, there is that almost employer relationship, but it is possible, however, to legally have a position where the individual is self-employed.
Yeah, absolutely. And just to plug the global talent route a bit further, you can quite easily be self-employed under the global talent route. You don't have to worry about those various concerns, which again is just another example of the global talent route being quite flexible. Once you do get on it, you do have that barrier at the start with the endorsement process as well. So, and then just a question here, can I switch from the skilled worker dependent route to the skilled worker route? You can certainly switch, but as I was saying earlier, it does restart your skilled worker residency period for the purposes of settlement or indefinite leave to remain. So it is, as I say, always worth checking the switching requirements when you are thinking about this. So although it's absolutely possible to switch from skilled worker dependent, before you do it, before you jump ship, it's always worth thinking about what that means for your indefinite leave to remain settlement journey, as it were. Often people don't do it, and once you have switched, it's effectively too late. You're kind of already stuck on that new pathway, and the time you've accrued isn't necessarily useful for yourself, although of course it can be used for the 10-year long residence route. I've had quite a few clients who've just sort of done it and then come to us after the event and said, oh, what does this mean? And by that point, it's already too late. You should have had advice beforehand. There is information out there. We can certainly provide information on this. So do make sure you're aware of that before you do it. Irfan, do you have any other questions that have come in to you at all, or any other questions, points that we think we can cover?
I think we've pretty much covered. I think most of the we covered most of the questions that do normally crop up. And I think the other thing just to take away as well is I think a lot of especially with students who finishing their studies or come to finish their studies looking for a job, I think sponsorship now, it doesn't come as a given, and I think many employers have been just revisiting the business models, and they're looking at to see whether or not they want to go around the sponsorship route. So I think it is worth always exploring other options if sponsorship is not not immediately available to individuals. But yeah, I think it can be it can be quite tricky to get onto the skilled worker visa route.
Yeah, absolutely. We do sympathise. The last year for UK immigration law, we have seen the Home Office really make restrictions that have made lives more difficult. So we do understand that. We do see it every day in we do appreciate there is concern for some people about the various options available to them, which we're trying to argue against with the Home Office as much as we can, but it's a small voice against the wind. But on those notes about, I'd like to say optimistic notes about what we're trying to do. We are very happy to be contacted by yourselves individually. We've got our emails there. Do email us if you have any questions or concerns, or indeed want some further information at all. And I'll hand back to you, Rihanna, for any closing remarks at all.
Yeah, thank you guys. No closing remarks really from me, just to say thank you for such an insightful discussion. Those case studies were particularly useful. I hope all of the students and recent graduates here have found that really useful to see how to apply the knowledge to specific scenarios. Like I said, we will have recorded this session, so we'll be uploading it to the Careers Discovery feed in the next couple of weeks, and it will be advertised in December's International Careers newsletter. But yeah, just a final thank you to our hosts, Nick and Irfan, for a fantastic presentation, and to our very responsive students in the audience for asking so many great questions. But enjoy the rest of your evening. It's been lovely hosting you.
It's been lovely to be here. Thank you for having us. Bye-bye.
Thanks, everyone.
Bye.
Bye.
Bye.